Hello, UCAR. Peter Christensen here. Hope you find yourself well on this fine June day. I'm assuming maybe you watch this in the middle of the night. Fine June Eve, then, to you. Either way, it's June. And that means a new theme. So, the theme for June is going to be agency. Agency. Why is that important for an agent? Could it be more important? It's in the name of what you do. You're an agent. So, agency. Yeah, every transaction, when you represent somebody else, you're acting as their agent. So we know we have agency forms, and that we harp that you should get those signed and get those in place. There are varying practices on the timing, on how they do it, whether they do it prior to showing their first home, or whether they do it as they're writing up the offer, or somewhere in between. I always have preached that the sooner the better. And let me tell you why. Just a little primer for this next month and the topic. Because agency is a big deal. You're required to have it in writing by the state and the Code of Ethics as well. Neither gives you a great time frame. Neither of them says explicitly, here's when you have to have agency in place. You definitely need to have it in place before the offer is made, right? Because at least before it goes under contract. Well, no, I'd say even before you submit an offer, you should have that agreement in place. I think that's when you see people start to get hit by the state with fines when they didn't have it in place. The Code of Ethics certainly could be in violation of that by not having your agency agreement and submitting offers without it. I think it's pretty rare that that happens, but sooner rather than later. Why? Well, you're acting as what the law considers or calls an implied agent prior to that anyway. So if somebody asks you to help them do something and you say, yes, I'll do it for a fee, and you arrange the fee, then you become an implied agent in the eyes of the law. That's a little oversimplified, but that's the basics of implied agency. So the law, and you're holding yourself out as an agent as well, because you're representing someone. You're telling people, yeah, I represent these buyers, I represent that seller, whatever the case may be. So you are, whether you have a written agency agreement or not, you are going to likely be considered an agent in the eyes of the law, which means you can pick up liability. With no reciprocal promise, you don't have any agreement with the people to stay. So it's also what we consider a non-exclusive agency arrangement if you're just an implied agent. It means that client can leave without any notice, can go and hire someone else. So there are some drawbacks to implied agency. So as we talk about this, understand the importance of agency, getting those agreements in writing. The law requires it, the Code of Ethics requires it, and you're picking up the liability anyway prior to that. We'll dive in deeper throughout this month. If you have questions concerning agency, throw them in a comment, and I'll see if we can hit those with the next posts. Remember, as always, this is not intended as legal advice. This is legal information only. If you need specific legal advice, contact your attorney. I hope you have a great day, and we have a lot of fun with agency in June.